Hello and welcome to the Federal. In what is being hailed as a landmark observation, the Orissa High Court recently said that sex under false promise of marriage does not amount to rape. Now, this order compels us to revisit the old debate of whether sex under false promise of marriage should that be termed as rape. Now, to shed more light on this issue and revisit the discussion, we have with us renowned journalist and documentary filmmaker Deepika Bharadwaj and advocate Nagasaila. Cutting straight to the chase, what is your view on this order?
I think the what the court has done is absolutely right in this particular case itself. But the larger issue here, Niveta, that I really want to talk about is the confusion, which is, uh, you know, just getting deeper and deeper in the legal, in judiciary uh, regarding this whole idea of rape on false promise of marriage. Some court says, it is rape. Some court says it is not rape. This judgment has been passed while granting bail to the accused, and in that, the judge has said that while it is absolutely true that there are women, especially in the lower social economic zone, and marginalized women, or women from the women who are not so educated or something, they are definitely lured on, by giving false promises, and then having sex with them, and then abandoning them once they get pregnant. But the judge has also said that it is the agency of a woman to decide whether she wants to consent to a certain act or not.
Now, at the time of bail, frankly, the court need not have gone into this entire discussion about whether it constitutes rape or not, because these are all matters for trial. So now the law makes a very fine distinction here. When at the very threshold, at the time of making that promise, if the person who is making the promise did never have the intention of of actually honoring that promise, and the very intention of making that promise was to induce the woman to consent to sex. So if this was the primary intention, and it was done with that kind of an intention, and with no bona fides in this entire thing, only then it will constitute an offense of rape.
Somebody making a false promise, and that amounting to rape, is just something that we are seeing happening a lot after the Nirbhaya case after 2012. There has been sport of these cases. Since I'm making a documentary right now, which is bringing out the loopholes in the rape law and how it's being misused, it's called India's Sons. I have gone through n number of these judgments, and we are obviously doing a lot of data crunching. Uh, you will be surprised to know that in some states, in fact, Odisha itself, um, um, the number of rape cases on false promise of marriage, which are now being documented separately in National Crime Records Bureau, are from the range of 40% to 80% as well. So these cases where the court is not even clear what is rape or what is not rape, the person gets arrested, the person is tried for an offense of rape, but you're still putting the person behind bars. For example, this boy in Orissa case, which we are discussing today, this boy was in jail for 6 months.
In the Orissa case, it appears the judgment says that it is the girl is 19 years old, and the statements say that they have been in a relationship for about 4 years. So if you work it backwards, then at the time of the beginning of the relationship, the child must have been a minor.
Yeah.
See, because if it's a consent by a girl who's under 18 years, it is not a valid consent because the girl is a minor. Sexual acts were commenced at a time when the girl was a minor. So which means it would be a statutory rape. I mean, when we use the word statutory rape, what we mean is that her consent is immaterial.
Other than this case, if it was not, they were not minor, how would this play out? Let's say if it was a 22-year-old woman, but the scenario was same. Do we not take that as consent? Like the woman who knows that she's getting into a physical relationship, can you completely rule her out as innocent?
That is why a lot depends on the facts. You can't make it as a thumb rule to say that wherever two consenting adults have, got into a consensual physical relationship, probably under the belief that it will culminate in a marriage, but for whatever reasons, the relationship has fallen apart. So every such scenario will not constitute rape. That is why I said a lot depends on the facts of each case, and it also can be decided only at the time of trial. These cannot be done on the basis of just the registration of an FIR, at the stage of registration of the FIR, or at the time of consideration of bail. These facts can never be elicited, because ultimately it is only a matter of evidence and trial, where each one will be subjected to cross examination, and there will be more detailed examination of how the entire relationship was built.
I'm not like reducing the sensitivity of this for crime like rape. But I think so much of subjectivity into what constitutes a crime and what does not constitute a crime leads to bigger problems than actually solving the problem in the first place. It is called rape when the woman did not consent. There was no will and consent of the woman involved, or if she is given an intoxicating substance because of which she could not communicate consent, or she's under 18 years of age, or she's threatened, or her family member is threatened of certain crime, and then she gives consent under duress. And now all of these rape and false promise of marriage of cases are basically coming from this one point in the explanation of when it is rape, where it says misconception of fact, where the woman believes the man to be her husband when he is not the husband. Okay, so my question is, when somebody just makes a verbal promise, how can that become a marriage? In this case also, they were in a relationship for 4 years. Now if you have relationship for 4 years, you're with this person, and then you then go and say that he was raping me for 4 years, I think it just reduces the intensity of the crime that rape is.
An allegation of rape is a very, very serious offense, which has very serious consequences for the accused. So while we might be tempted at an emotional level to get indignant and angry, which is very valid in the current social circumstances, the graver the nature of the accusation and the offense, the more careful we should be in weighing the evidence.
There's also a parallel narrative which says categorizing this under rape laws itself takes away the seriousness of actual, like rape, which is the most heinous crime. So, does this require to be categorized under rape laws?
See, the offense of rape, the way it stands today, the definition in the Indian Penal Code, does not contemplate directly a situation that we are discussing today of people who have been promised marriage and who have been subsequently let down. All that the law says is that if you have put a woman through sexual intercourse without her valid consent. So what consent is defined under section 90 of the Indian Penal Code. So consent is something only when it is valid, only when it is voluntary, and when it has been got without fraud or misconception.
Sort of cases are on the rise, especially given the times of dating apps. People tend to get attached easily in relationships. So there's always this problem of communication. One person wants something out of a relationship, another person wants something more out of the relationship. And when that communication does not happen properly, and when, if at all, the relationship ends, do you think it's easier for the women to take advantage of the situation?
Absolutely. I remember a case from Bangalore where the girl and the boy actually met on Tinder or some dating app. So they met. I think they had sex on the second day or third day of being swiping with each other on this app. And within 3-4 days, the girl asked the guy that you got to marry me, and the guy said, "What?" And she said, "Yeah, you've had sex with me, so you got to marry me." And the guy said, "No." And she charged him with rape.
Do you think there is a need to revisit these laws, the way, at least this sex under false pretense of marriage? Should it be revisited now, given this social circumstances?
See, in a way, yes, because you will see there is also the fact that very often, because of the caste and the religious prejudices in our country, very often the woman is, forced to give a complaint. So there is a lot of abuse of law as far as this is concerned. So now, for every abuse of law, if you start saying that it requires a different category of offense, we can't factor in every such situation of abuse. Any law can be abused. For instance, Dowry Prohibition Act. People say there are false cases.
Yeah.
It is true that there are false cases, but it is also true that there is a lot of dowry harassment. So unfortunately, that many people are coming forward. There is no law which is not abused today in our country. So every law is abused. So if we use abuse as a measure or as a yardstick to keep changing laws, then there is no end to it. So when you're making an offense of rape, a charge of rape, it is very serious, and we as a society, we will have to make these complaints with responsibility, with a sense of responsibility.
Thank you so much for joining.